Allah is my lawyer right now. And if you do not release me, Allah will have his vengeance on you. Like he did in 2009 when he sent that flood. It's only going to get worse.
First up, we have 32-year-old Sahara Fakir in the Douglas County Courthouse. She has been charged with armed robbery, burglary, and murder in Douglas County Courthouse, and during her trial, she made all sorts of bizarre comments and incessantly referred to Allah right after the judge briefed her on her crime.
And if you are judging me and you're not God-fearing, Allah will have his vengeance on you, and everyone else is not God-fearing. Understand that.
But she didn't stop there. When the judge asked her about her legal representation, she started another round of cringeworthy comments and kept on referring to Allah, saying that he will have his vengeance on the judge if he doesn't release her.
Do you have a lawyer?
Allah's my lawyer right now. He's speaking to me.
Are you going to get a lawyer?
However, the judge was unfazed by her frequent ramblings and threats, so he continued with the hearing and found Fakir guilty of all charges, sentencing her to life imprisonment without the possibility of parole. Next up in the Miami-Dade courthouse, we have Calvin Lloyd Griffith, who was arrested and charged with grand theft, burglary, and trespassing after he broke into a school and stole an employee's car. During his court hearing, he accepted his presence, saying that he was supposed to be there because he smokes.
Oh, be here anyway because I smoke weed and cocaine.
This forced the court officials to turn off his mic in order to stop his unnecessary rambling. But as the judge looked at his paperwork, Griffith tried to interrupt the court once again, but since the judge was unable to hear him, he tried a more catching method. Displeased with his attitude, the judge sets his bond at $18,500. At the 17th Judicial District Court in Idaho Falls, Idaho, we have a 50-year-old former high school teacher, Brian Johnston, who was found guilty of felony stalking of a 26-year-old former high school student who he had reportedly been dating. According to reports, he had violated a restraining order filed against him when he followed the woman in public, sent her harassing messages, broke into her home, and allegedly urinated on her bed. Facing a 5-year jail sentence, Johnston visibly trembled as he read out a remorse note that he had previously written.
I sincerely regret and feel deep sorrow and accept full responsibility for that which I have done. I hope and pray that she will be able to heal from this and not have any lingering impact to her life.
The judge, convinced that Johnston had two personalities, said that he had received several letters from Johnston's supporters.
This is a Dr. Jekyll, Mr. Hyde case, and I get a lot of letters who really support Dr. Jekyll. But I'm sentencing Mr. Hyde.
Regardless, he sentenced Johnston to a court-regulated rehabilitation and 4 years of probation. Next is a virtual court hearing in the 17th District Court of Fort Lauderdale, Florida. We have Demetrius Lewis, who had been charged with the possession of illegal substances and attempted burglary, which could land him a minimum of 5 years in prison. However, Lewis seemed to be less concerned about his likely jail sentence and chose to compliment the judge's looks, claiming to be in love with her.
Judge, you are so gorgeous, the judge. I just have to tell you, you're gorgeous.
Thank you, Mr. Lewis.
This earned him a lot of eye-rolling from the other Zoom participants, especially from prosecutor Eric Linder. The judge, however, focused on the case and subtly warned Lewis that flattery won't affect his sentence. She listened to the state's recommendation and set his bond at $5,000. It's not uncommon for defendants to put up a fight against prosecutors or be rude to other members of the court. But at the 12th Judicial Circuit Court in York, South Carolina, was LaMarcus Williamson, who aggressively went against his own attorney. Williamson faced a 15-year sentence as he had been charged with robbery and aggravated assault after he allegedly choked a college student 6 months before. Interestingly, his attorney was York County Public Defender Dan Hall, who was celebrating his 58th birthday on the day of the court hearing and was only filling in the former attorney who had handled the case up till that point. As Williams' sentence was about to be read, the constable predicted that there may be trouble and signaled other officers to be alert. It turned out that the constable's suspicions were right, as Williamson delivers a strong punch to his attorney as the judge hands him a maximum sentence of 15 years imprisonment. The two men rolled on the ground, and the standby officers quickly jumped into action, separated the two men, and led a handcuffed Williamson out of the courtroom. However, this violence didn't go unpunished, as Williamson was charged with criminal contempt of court and sentenced to an additional 6 months imprisonment. Yet again, in the 17th District Court of Fort Lauderdale, Florida, We have 32-year-old Yaneli Marie Morales, who had been charged with burglary with assault or battery after she reportedly broke into the house of a woman who had allegedly been having an affair with her boyfriend. During her court hearing, her public defender requested to have one of his colleagues, an appellate attorney, to be present during the ruling and promised that he'd arrive in 20 minutes. But after 20 minutes, his colleague was nowhere to be found, and the judge felt disrespected, saying that it only took 2 minutes for the attorney to get to the court from her office.
The attorney asked to be here 20 minutes ago, and she is not here.
Judge, but
it
now
shows a blatant disrespect to this court.
Judge,
Mr. Armstrong?
No.
It's about a 2-minute walk from the public defender's office. Where is your colleague?
Not too long after, the judge pointed out that Morales' attorney was making conflicting arguments and requested clarification. But when the attorney was unable to give a coherent response, Morales was released 3 days after at her next hearing with a $10,000 bond, court-regulated rehabilitation, and a 4-year probation. At the Kern County Superior Court in Bakersfield, California, we have 27-year-old Tobias Roman, who was charged with attempted robbery, threatening with intent to terrorize, and exhibiting a deadly weapon for stalking a female employee at a mall. During his hearing, the judge asked him to stand up, which he obliged to, but not without asking a daring question. The judge, however, ignored this and proceeded to ask the defendant for his real name, which he said could be either Tobias or Giggles.
Mr. Roman, what is your true and correct name?
Tobias, my first name, that's it. Giggles or Tobias, that's it. Don't call me nothing else.
But as the judge read out Tobias's charges, he interrupted and told him to be quiet. Once again, the judge ignored the interruption and warned Tobias that he will be removed from the courtroom if he interrupts him again. But Tobias ignored this and gave a snarky reply, which caused him to be let out of the court. However, as Tobias was let out of the court, he threatened to kill the judge, and this earned him 8 months in prison. Next, in Christie's Beach Magistrate Court in Adelaide, Australia, we have 35-year-old Daniel Nicholson, who is awaiting his sentence for weapons charges with the hope that he'll get a pre-trial release. But things went south for him as the judge revoked his bail. At first, Nicholson begged the judge to reverse the sentence, but when she didn't budge, he decided to take matters into his own hands.
Revoke bail. I revoke bail. No, you can stop.
What's going on, Father?
Take a seat. Take the seat.
Miss, please, miss.
Please, miss. I'll tell you what, please, miss.
He was eventually tackled by officers and taken out of the court. Soon after, he pleaded guilty to attempting to escape custody and recklessly causing harm to a prescribed emergency worker. He was ordered to pay a $320 fine for the original gun charge and sentenced to 21 months in prison and is only eligible for parole after 1 year. Up next is Daniel Roberts, who is at the Washtenaw County Trial Court in Ann Arbor, Michigan for his hearing. He was charged with unarmed robbery, refusing fingerprint, assault with intent to rob, and larceny. Roberts insisted on representing himself and refused all forms of professional legal counsel and was soon declared incompetent. However, this didn't bother him as he asked the judge a question he'd been aching to ask. But when he didn't get a satisfactory response, he resorted to violence but was quickly subdued by court officials.
What about my discovery? Let's talk about that.
Oh, let's not. Not right now.
Eventually, he was declared competent and was sentenced to 1 year and 10 months in jail. In Harlan, Kentucky was 59-year-old Cletus Robbins Jr. in the Harlan County Circuit Court. He had been arrested and following his 3-day trial, charged with multiple counts of crime, including kidnapping with serious physical injury and robbery in the first degree, second-degree assault, unlawful imprisonment, and wanton endangerment. Minutes into Robbins' hearing, Assistant Commonwealth Attorney Jonathan Lee asked him not to talk to anyone else at the table other than his lawyer, as that was the normal rule. But apparently, Robbins didn't like that, and he expressed his disagreement in the most uncultured way imaginable and pressed on even after the judge hinted that it was unnecessary. Later on, the judge handed him a maximum sentence of 25 years, but Robbins didn't like the sound of that, and he chose to spit at the prosecuting attorney, who hurriedly jumped out of his seat. This led him to be removed from the court, but as Robbins was being let out of the court for misconduct, he let out one final threat. Luckily for him, however, no additional charges were filed against him. Still in Kentucky, but this time in the 49th Judicial Court in Scottsville, we have 42-year-old Timothy Madden, who who had been arrested 4 years earlier for the kidnap, rape, and murder of a 7-year-old girl. As the victim's family was about to read out their victim impact statement, Madden was seen snickering with his lawyer, and that didn't sit well with the victim's father, who chastised Madden and told him he was being disrespectful. This caused quite a ruckus.
Sir, that's the most disrespectful thing I've ever seen. Give us just a minute. We've had 4 years waiting.
And the judge decided to calm things down on her own. Her strategy worked, as the victim's mother was finally able to read her victim impact statement after the 25-minute-long ruckus. Following that, Madden was handed a life sentence without the possibility of parole. At the Berea Municipal Court in Berea, Ohio, was the probation hearing of 18-year-old William Demopoulos, who was charged with criminal damage, unauthorized use of motor vehicle, and obstructing justice. At the beginning of the hearing, Judge Chris Green asked William to hand over his phone, and that was when all hell let loose, as William vehemently refused and tried to run out of the courtroom even after the judge explained why he needed to hand over his phone and ordered the court officials to put him in handcuffs.
When you are on probation, your probation officer has the right to take anything they want to take of yours. If they want to search your phone, they search your phone. The problem is, you don't want to play by anybody's rules. You want to play by your own rules.
Following that, the judge revoked his probation, charged him with resisting arrest, and sentenced him to 40 days in jail. Now, at the Seminole County Court in Sanford, Florida, was the one-day trial of 46-year-old Lisette Gonzalez, who was charged with driving under the influence and was found guilty by the jury at the last minute. Gonzalez's attorney made one final plea to the judge, stating that his client was not assessed with a breathalyzer or had her blood drawn. However, the arresting officer reported that she tested above the limit and respectfully requested the court to grant a retrial.
Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge.
In an uncommon move, the attorney asked the judge to overturn the jury's verdict and acquit the defendant. The judge seemed to have made up his mind as he engaged the prosecutor in a heated argument, dismissing the charge and granting Lisette a judgment of acquittal, JOA. Up next, we have Tex McIver, a 75-year-old former attorney standing trial in Atlanta, Georgia. He had been charged with felony murder in connection with the death of his wife, Diane McIver. According to him, he had accidentally shot her on their way back from their horse farm. Following the customary procedure, the victim's friend read the victim's impact statement, but when it was time for Tex to make his own statement, he talked about everything except the crime he was being charged for. In fact, he made it a point to mention that his grandson's favorite sports team was the Warriors. The judge, utterly dismayed by the unnecessary waste of time, sentenced Tex to life imprisonment with the eligibility for parole set at 30 years, when Tex would already be 105 years old.
Then there is the most unique individual I think that I've ever corresponded with. His name is Trent Jones. He's a racehorse jockey in Perth, Australia. His favorite racehorse, Fullest, has been retired just this year.
Finally, in Hamilton County Courthouse in Cincinnati, Ohio, we have Anthony Kirkland, who is charged with 4 counts of murder, rape, and voluntary manslaughter. In 1987, he was sentenced to 10 to 25 years in prison for raping and murdering a woman who refused to have sex with him, and was only just released on parole in 2004 when he began the cycle again in the period between 2006 and 2009. He had raped 4 women, 2 of which were 13 and 14 years old. He strangled 2 of them and burned their bodies to conceal the evidence of rape. During his hearing, Kirkland only heard 3 of his 4 charges when he fainted.
Kirkland, you are charged with the following offenses as contained in the indictment. Count 1, attempted rape with specifications. Count 2, aggravated murder with specifications. Count 3, aggravated robbery with specifications. Count 4, aggravated murder.
However, the jury wasn't moved by the show and recommended the death penalty. After his revival, Kirkland addressed the court, saying he didn't blame them for wanting to kill him because he deserved it. He definitely did deserve it.